I want to walk you through what might be occurring any time now, or maybe not, so you are more informed about the Constitution and the consequences of what may take place, maybe not, with Mr. Mueller and a subpoena. I think it's very important that the millions of you who listen to this program know about it, because you're going to be fed more propaganda than you can imagine should that subpoena take place. So I consider that enormously important that you stick with me. The Mueller team has to make a decision now. I don't know what the president's lawyers have proposed to Mr. Mueller, but they're good lawyers. Sekulow, Giuliani, Flood, there may be others. They're good lawyers. And based on what Giuliani said in reading the tea leaves, they have very narrow parameters for this prosecutor. No, you can't question the president about his presidential prerogatives, like firing Comey. You have a public record. You know why he fired Comey. This president explains more about his actions than any president I can think of. He uses Twitter. He goes to rallies. He speaks on other forums and so forth. But it's none of Mr. Mueller's business, period. And questions cannot be asked for the purpose of trying to catch the president in some kind of a trick and then claim that he made a false statement or he contradicted somebody and therefore he perjured himself. And there are other issues that should have been and may have been raised by the president's lawyers. And let me go over some of them. Now, I don't know this, but this is what I would do. Mr. Mueller, what is your authority to question the President of the United States under our Constitution? Not any public official, not any citizen, but the President of the United States. What is your authority? If you agree that you must comply with the Department of Justice's policies, and the Department of Justice's policies include two memos that stretch almost half a century by two different administrations from two different parties that have never been altered, that state unequivocally that it is the position of the United States Department of Justice, your boss, that you cannot indict a sitting president, then what exactly is it that you want to glean from this president in terms of a criminal prosecution? It's not the target. He hasn't committed any crime. There's nothing in the federal code. You better have a damn good reason. Now, we're not talking about turning over documents. We have, the Nixon case where Nixon was forced to give over the tapes. We're not talking about giving over tapes. We're talking about physical access to the President of the United States. That's quite different. Quite different. We're not talking about a civil case. We're talking about a criminal case. The President of the United States has never been subpoenaed successfully to appear in front of a federal grand jury. So, Mr. Mueller, exactly what are you up to? Now, Mr. Mueller, you're either one or another kind of federal official. Are you an inferior official under the Appointments Clause of the Constitution? 3 judges, federal judges in Washington, D.C. have ruled that that's what you are. You're an inferior official, an employee of the Department of Justice who reports to the Deputy Attorney General of the United States. Do you agree with those decisions? Or are you a principal officer? Under the Appointments Clause of the Constitution, stay with me, under the Appointments Clause of the Constitution, and therefore you should have been nominated by the president and confirmed by the Senate. Otherwise, everything you've done is null and void. Which is it? Well, he would obviously argue, I would think, that he is an inferior employee, that he reports to the Deputy Attorney General of the United States, who is the acting Attorney General for these purposes. Fine. You're an inferior employee. Inferior to whom? Well, the Deputy Attorney General. To whom else? The Attorney General. Who else? The President of the United States. So you can subpoena your boss, even though your boss argues that for the purposes in which you seek to subpoena, you do not have the power? Now, if that's the case, you're not an inferior employee, are you? But if you are, and I, as your superior, your ultimate superior, I'm the executive branch, I'm President of the United States, how can you subpoena me? To physically appear in front of a grand jury, or physically appear for your questioning. This would completely turn upside down. Separation of powers, the Appointments Clause of the Constitution, and the structure of the executive branch. This is what I mean, that this man is more dangerous to our constitutional system than Vladimir Putin. Putin is, without question, a danger to this nation. It has nothing to do with national security. So the dense Washington Post reporter, this is way above his IQ level. But all of you understand what I'm saying. These are important points. Stay with me. These are the kinds of points that will be argued in a constitutional confrontation. Now, Mr. Mueller and his lawyers are not constitutional experts. Some have argued in appeals courts. Some have argued in front of the Supreme Court. But they're not experts, per se, in this area, in any respect. Moreover, Mr. Mueller will be opening the door to allow the president's attorneys to bring up any and all related matters involving the nature and course of this investigation. Now, that doesn't mean some liberal judge or justice or court won't knock them down. But the door will be opened where they can challenge so much of what Mr. Mueller has done and the nature in which this investigation was launched. And so Mr. Mueller has quite a high hill to climb, assuming he doesn't have a bunch of liberal judges who want to help him out. Why do you want to subpoena the President of the United States? What is it that you need to know? I need to know why he fired Comey. Excuse me, 2 points. You don't get to know that, but moreover, there's a public record. He said why he fired Comey. Well, he gave 3 different answers. Wow, now you have 3 answers. But you're an inferior employee. You report to the Justice. Now, why is this important, folks? You cannot have any assistant U.S. attorney issuing subpoenas for a president to appear in front of a federal grand jury to ask a bunch of questions which they claim they cannot get answered without forcing the president in front of a grand jury or demanding an interview of the president in a criminal matter. The courts would be unleashing things they don't even know that they're unleashing. It would completely undermine the power of the presidency. On the other hand, the president must defend his prerogatives. He must defend the right of a president, any president, to fire a subordinate. To fire a subordinate. He must defend the rights of presidents not to be forced to appear in front of federal grand juries at the demand, effectively, of an inferior employee. Now, Mark, Judge Starr, he issued a subpoena for the president to appear before a federal grand jury. That is Clinton. Well, Clinton should have fought it. But they are 2 completely different cases. Clinton, in conducting himself the way he did, wasn't protecting a presidential prerogative. Clinton's actions involved Clinton's actions. You see, the issue of whether Clinton committed perjury in a civil trial has nothing to do with whether a president of the United States is able to fire the FBI director. Also, think of it this way. If a prosecutor is free to question a president about his prerogative to fire a subordinate, look at the opportunities for political blackmail from future FBI director, future CIA director, future national security intelligence, all of them. I'll be right back. You see, if Mr. Mueller issues a subpoena, it is Mr. Mueller who's going to have a lot of questions that are going to have to be answered. But I believe it's quite possible he will. I don't know. I'm not predicting. I'm just saying I find him to be extremely irresponsible. There's a piece at ABC News. What happens if Mueller decides to subpoena President Trump? And they ask a bunch of law professors or former prosecutors and that sort of thing. Peter Shane, professor, Ohio State University. Is it smart strategy for Mueller to issue a subpoena on the president? He says at Moritz College of Law, I would say yes, because the evidence that the president could give would be, in my judgment, directly relevant to the plausibility of charges that involve not only the president but other people involved in his campaign, including family members. And I think that as a prosecutor and former FBI director, that Mueller believes in dotting as many I's and crossing as many T's as possible. I don't think he would want to leave this particular stone unturned. I have no idea what that means. None. Question the president about what involving family members? You question the family members. All right. Somebody by the name of Whiting. Their answer. There are risks for Mueller in terms of whether to seek a subpoena. The first is delay. It would be litigated, and that is a fact, by the way, and it would take several months to be litigated. So he'd have to decide whether and how the delay would affect his investigation. And the second thing is he could lose in court. I don't think he'd lose in court, but there's always a risk of losing in court, and so we would have to calculate how important it was for him to get the interview versus the risks. That's why this has dragged on for so long. Both sides are negotiating in the shadow of these risks and trying to press their positions and see who will blink first. Stephen Saltzberg, George Washington University professor of law, former associate independent counsel. Better not to subpoena the president because it could be litigated for 18 months or more. Mueller has sufficient statements by the president to know why he did what he did. That is a fact right there. There's no reason for any of this. So in my view, the professor and former associate independent counsel probably knows better than the rest. Somebody named Welly. I'm confident that what's going on inside the Mueller investigation is only remotely related to what we know about at this point. So it's possible he has what he needs and doesn't absolutely need the president's testimony. So he could walk away from it, or he could issue a subpoena. Well, thanks for nothing there, pal. What would prompt Mueller to issue a subpoena to the president? Is the question posed by ABC. They go to Professor Prahash of the University of Virginia. Giuliani's been all over the press about how the president wants to testify, but not with respect to all of these questions about obstruction of justice. This has been going on for months. Perhaps Mueller believes that he just has to ask these questions and play this out to see what the president's response is. Well, that's a foolish answer. Back to this guy Whiting. Mueller would have to decide either that Trump's team is not serious about sitting down for an interview, or that the conditions they are seeking to impose are so restrictive as to make the interview not worthwhile. And if Mueller decides that one of those two things has happened, then that's when he would have to make a decision about whether or not to seek a subpoena. Wiley. This is all really just a game of chicken. We can go round and round and round, and what all this comes down to is the president is saying, make me. I'm going to comment on this in a second. Paul Rosenzweig, Senior Fellow, R Street Institute, Professorial Lecturer in Law at George Washington University. I'm quite familiar with this gentleman. Quote, one of the best arguments against wasting time on subpoenaing the president is that since there is a Justice Department policy that says the president can't be indicted, and Mueller's probably decided in his mind that he's going to follow that policy, it doesn't really make that much difference what the president says. If you're not going to charge him with a crime, who cares what he has to say, right? I think that I care what he has to say, even if it's not capable of being criminally prosecuted, because I think that the truth value of knowing what happened is greater. Well, that's a stupid answer. If and when Mueller decides to subpoena President Trump, what happens next? Wiley, that's the federal government basically saying, you do this or else. That's what a subpoena is. It is saying to the President of the United States, if you don't comply, we, the government, are going to make you comply. Now, listen to that. The President is the executive branch. This is an inferior employee if you listen to the so-called experts. So this inferior employee can say, we can make my boss comply with this. This is what I mean. The courts are playing with fire if they go along with this. Salzberg, the former Associate Independent Counsel, quote, the president could comply or he could file a motion to quash the subpoena on the ground that it is a burden on the presidency. And that's true because he's obviously read the memos out of the Department of Justice. Somebody by the name of Shane. The reasons for objecting to the subpoena have to do with whether a president may subpoena it for testimony at all. What the president's lawyers are going to say, I'm virtually certain, is that the court has no authority to demand that the president give personal testimony. Professor Prakash, I think the president would then invoke executive privilege. And I think the special counsel at that point would try to contest the invocation, saying it doesn't apply, and therefore the president has to testify. And so that would be litigated, and the court would have to decide whether the special counsel could actually contest the president's claim. If they decide that he couldn't, that would be the end of the subpoena. He wouldn't be able to enforce it. Rosenzweig. If they are at an impasse and Mueller issues a subpoena, the president has a decision to make. He can comply with the subpoena. That means showing up in the grand jury and answering questions like any other human being who's subpoenaed to testify. Option 2 is the one that President Clinton chose in the 1990s, which was when he was subpoenaed by Ken Starr. That was when Clinton's team finally sat down and negotiated. Third thing the president could do is fight. He could go to the court and say, look, I'm the president. You can't subpoena me. I refuse to come. That fight would start in the District of Columbia with a grand jury's meeting, and pretty obviously, it would go all the way up to the Supreme Court. I predict that's what would happen. Whiting. The other thing that could happen is Mueller could issue the subpoena, and then that could start negotiations again. If they see that Mueller's willing to issue a subpoena, then they might reassess their risks. Then they ask, how long might a court battle over subpoena take? Prakash, president, try not to comply with any order until he gets a decision from the appellate court or from the Supreme Court. If a district court ordered him to testify, I suspect he'd say, I'm going to appeal this and try to prevent the testimony from being given. Whiting, certainly be expedited because this is an ongoing investigation. So there's a pressing need to resolve it. And also I think the judge would know that both sides have fully thought through their arguments and so forth. Rosenzweig, I would expect everybody would work very hard to expedite it. Shane, there's an interesting question as to strategy because there are two elements of strategy, two objectives. One is winning, the other is delaying. Let me just say this, folks. You can delay and win. If the subpoena fight reaches the Supreme Court, who is likely to prevail? And then when we're done, I have a question for you. What haven't they asked over there at ABC News? Prakash, unlike the Nixon case, they are not asking for evidence, for documents or tapes. They're asking for the president's testimony. I don't know what the court would say about trying to get the president to testify as to whether he had the requisite state of mind for obstruction of justice or whatever else the special prosecutor is investigating. And I don't know what the court would say about the applicability of executive privilege in that context. As far as I can tell, the special counsel doesn't have any explicit litigating authority to contest presidential assertions of executive privilege. That was a feature of the regulations in place in Watergate era. It wasn't readopted for whatever reason when the Clinton administration put out these special counsel regulations. Shane, I would be a little surprised if the Supreme Court were to take the position that executive privilege with regard to testimony was absolute. The accountability of any one branch of government to any other branch. Stop! It's not the accountability of one branch to another branch. It's the same branch. That's the point, Professor. It's the same branch. It's the executive branch. He's an inferior employee if you buy that argument. If he's not an inferior employee, if he's a principal employee, he's out because it violates the Appointments Clause. That's why he's kind of boxed in, Mueller. What else does he say here? I think what's going to happen is the decision is not going to be you can never subpoena the president, and it's not going to be you can subpoena the president just like any other citizen. It's going to be somewhere in the middle. Rosenzweig, in the end, my prediction is 75 to 25% that Mueller wins. All right, this guy, I don't even know why this Rosenzweig's involved. Then they ask if Trump could defy a court order. And that's all speculation. What didn't they ask, Mr. Producer? If Mr. Mueller issues a subpoena to try and force the president to testify in front of a federal grand jury, what potential damage might he do to the Constitution? You see, ladies and gentlemen, the framers hoped that men of high virtue would serve in high office. But they felt that it was unlikely in many cases. So they created the appointments process, and certain people are elected, and checks and balances and all the rest. The problem is this prosecutor is not checked or balanced. He's a cowboy. He's rogue. He doesn't have a function within our constitutional order. The Supreme Court was wrong in Morrison, and they'll be wrong now to intervene on the behalf of a special counsel against another branch of government, the presidency. Vinny, Charleston, South Carolina, on the Mark Levin app. Go.
Hey, Mark, how are you?
Okay, how are you?
Good. Appreciate you so much. Hey, listen, I was just early on when the notion was floated about a subpoena being issued by Mueller to President Trump. Fox had someone on, a guest attorney, who recommended that he do nothing more than absolutely ignore it because that there's nothing they could do. They can't hold him in contempt, like you said.
No, that's not true. They can go to a federal judge and seek contempt.
But he can't be prosecuted, right, because he's the president, so I think that was the...
This has been my position from day one. They'll need to decide for themselves. They can claim executive privilege or just say, no, we're not going to do that. And a judge can issue a contempt order. But they have to play it out. The lawyers have to play it out, look at the different options that are available, consider how it'll play out. We'll be back tomorrow. More of this and more of that. We salute all you heroes out there, and I'll see you tomorrow. And enjoy Levin TV tonight. God bless.